It is a socialist movement to transfer immense amounts of wealth from the people who have worked their rear ends off to establish this or to create this wealth to the people who are living in the apartment buildings. I'm not going to say they're not responsible, and I'm not going to say they haven't worked hard, but they have not done the steps necessary to amass this wealth. So the state of California is transferring it to them for free.
Hi, this is Kris German. Welcome back to the Apartment Dealer Show. Today we have with us Mr. Mike Brennan, eviction attorney extraordinaire. Now, if you've been a subscriber to our channel of any time, you've seen Mike before. And if you're asking yourself, well, why do you keep bringing back the same eviction attorney? It's simply because Mike is one of the best, and he serves the local landlords here in Los Angeles County, San Bernardino County, Riverside County, Orange County, Ventura County. He has offices in multiple locations. And Mike and I today will dive into what are the current laws that have come into the books for 2022, what are the proposed laws for 2022, and with the recent extension of the Los Angeles County Eviction Moratorium, what does that mean to you and I as owners of multifamily properties here locally? Be sure to subscribe to our channel, turn on the notifications so that you receive the interviews as we record them throughout this year. Keep in mind, over the course of 2022, we're going to be releasing that much more content, and we will be bringing you the information, the resources, and the network of professionals that are going to help you build your financial legacy in multifamily properties. With that, help me welcome Mr. Mike Brennan. So Mike, thank you for being with us here today.
You're very welcome.
And so, of course, starting back in 2020, there's been a barrage of new laws, regulations, and just here days ago, Los Angeles County extended their eviction moratorium. And with that comes a number of not new, but extended regulations. And so we're going to dive into that today, Mike, and you're going to help us sort through this. So let's start there, of course, with the extension of the eviction moratorium, and let's help give the landlords some guidance of what are the new rules in place?
Okay, so I'm going to give you as you said, Kris, a 40,000-foot overview on this. We're still unpacking it and developing strategies for it. So for right now, it's probably best to start off by saying the state has its own COVID eviction moratorium that everybody knows is AB 832. Mm-hmm. And that the state's moratorium allows service of notices for unpaid rent. It has a preemption clause in it that prevents municipalities from their own moratoriums unless it was already in effect back in August 19th of 2020. But AB 832 expires on March 31st, 2022. And upon that expiration, municipalities can create, modify, or extend their old moratoriums. So that's really what the Los Angeles moratorium is doing. It talks about a three-tiered phase out of eviction protections. Realistically, phase one is actually an increase in protections. It's a step backwards, really. Beginning February 1st, the LA County eviction moratorium is extended, and that's the old moratorium. So right now you can still serve notices, you can still file evictions for unpaid rent. None of that changes. But on April 1st, then all of that changes. Now all of a sudden we go back to the protections for non-payment of rent that we had, a long time ago under LA County. And you will not be able to evict tenants for non-payment of rent. The really egregious part about that is that the tenants will be able to self-certify that they were impacted by COVID. Mm-hmm. And that means really nothing. They can make it up. They don't have to prove anything. The one thing they will have to do is notify the landlord within 7 days of rent being due each month that they've been impacted by COVID and they can't pay the rent, but they don't have to provide any documentation. They don't have to prove they've been impacted, and the landlords won't be able to evict them based on that. So that's phase one starting April 1st. That has no limitations on it. Every tenant, regardless of how much money they make, will be protected through phase two. Now, phase two is where we start to see a backing off or an easing up on the restrictions. Phase two starts June 1st of 2022. And at that point, several things go into effect that actually start to help the landlord. First, we'll talk about non-payment of rent because that's the most common. At that point, only those households that make less than 80% of the adjusted mean income for that area are protected. So in other words, if you make 81% or more of adjusted mean income, as of June 1st, 2022, you can now be evicted for non-payment of rent. The problem, of course, is how do you prove that a household makes what percentage of the adjusted mean income? And that's very difficult, but we're developing a strategy to work that out right now. The other protections that are starting to dwindle are owner occupied. Right now, LA County will allow an owner occupancy eviction, but there's a whole list of limitations on it. You have to have purchased the house prior to a certain date. If the tenant claims they were ever impacted by COVID, you can't do it right now. You've got to be in the same position as the tenant. In other words, if the tenant is disabled, the owner has to be disabled. There's a whole list of limitations. As of June 1st, a couple of those limitations are relaxed. So in other words, there will be no purchase date prerequisite. And even if the tenant has been impacted by COVID, the landlord will still be able to do an owner occupied eviction. So that's beginning June 1st. And then, as I said, the adjusted mean income kicks in so that you can evict people who are making 80% or 81% and greater of the adjusted mean income. Starting June 1st, you still cannot evict unauthorized occupants or unauthorized animals. You can't evict the tenant for unauthorized occupants or unauthorized animals, and you still won't be able to do nuisance evictions. Then we go into phase three, which starts, let me just double check the date on that so I don't get it wrong. Phase three starts January 1st, 2023, and that goes through June 30th. And at that point, again, the same AMI protections will be in place. 81% or better, you can file evictions for non-payment of rent. But at that point, there's no restrictions on owner occupancy, and all of the other eviction protections will be removed. In other words, as it stands right now, you'll be able to evict for unauthorized occupants, you'll be able to evict for nuisances, you'll be able to evict for unauthorized pets, you'll be able to evict for failure of the tenant to allow access. And going back just a little bit, in phase two, you will also be able to evict for failure to allow the landlord to come into the property. So they do phase it out.
So if we could stop there. So again, the recording of this video is February 2022. And because of these videos and because of YouTube and the work we've done together, I get, my office gets a number of calls asking us some of these legal questions. And of course, we always defer them to you, but I want to be able to at least understand some general answers here. So as of right now, for things like nuisance, tenants that are not allowed to live, or individuals living in the unit that are not lived in, that are living in the unit, you can evict for these things, or you cannot.
You cannot. You cannot evict for a nuisance. You cannot evict for an unauthorized occupant or an unauthorized animal. You cannot evict for the tenant refusal to allow access to the owner. This is all under the county's moratorium. Currently, you cannot do any of that.
So can you only evict then for, or I shouldn't say only, but it sounds like one of the main reasons then you'd be able to evict for, and it's a short window, is for non-payment of rent. But then in April, that changes, because if they self-certify COVID, then that goes away.
You got it. You just nailed it. Right now, you can evict for really two things. You can evict for non-payment of rent, and you can evict for any other breach of the lease except unauthorized occupants, unauthorized animals, and refusal to allow access to a landlord. And you can right now do an owner occupancy, but there's a whole list of requirements you need to meet, including one that says if the tenant's ever been impacted by COVID, you can't evict them. And all that starts to phase out. It goes backwards on the non-payment of rent, because as of April 1st, like you said, now all of a sudden you cannot evict for non-payment of rent. but that in phase two, that changes. Phase two starts in June of 2022, and you will be able to evict for non-payment of rent, provided that the household makes 81% or more of the adjusted mean income. And those protections start to diminish as time goes on.
And what about rental increases in LA County Incorporated? So my understanding is they've left it to the individual cities to basically determine if they want to put another layer. But if you're outside the unincorporated areas, you can raise rent.
That's correct. You got it perfect. Outside of unincorporated LA County, you can increase rents as long as there's no local moratorium in place prohibiting it.
And with the unincorporated component to this, it's interesting. I just found out yesterday that in Baldwin Park, there's a portion of the city that's unincorporated. Unbeknownst to me, and a client of mine owns an apartment building there. So unfortunately, she falls under those guidelines. But sometimes you might not even know that you're in the unincorporated area. So unincorporated differs, Mike, and you can better explain. But my understanding is not only have they extended their eviction moratorium to the end of this year, but they've also extended no rental increases for the remainder of this year.
That's correct.
So now we're going on 2.5 years where unincorporated LA has not allowed any rental increases. Anything a landlord can do in that respect, or it just is what it is?
The increases, there's nothing a landlord can do right now. I will tell you, Kris, we have a trade organization on which I sit on the board of directors. We have the approval. The board has already approved for us to go ahead and sue the county. We've hired a law firm. It's a law firm we've used in the past in these moratoriums. It's been very successful. And it is our intention to bring a lawsuit against the county because there's an aspect of this moratorium. It's the self-certification part that the United States Supreme Court has already ruled unconstitutional in a case out of New York that had the exact same self-certification allowance. The United States Supreme Court said, sorry, that denies the landlord due process. If a tenant is allowed to self-certify, the landlord should have the right to go in and challenge them and make them prove that in exchange for the waiver of rent, they have to show that they were impacted by COVID. So since the Supreme Court has already ruled that to be an unconstitutional component, LA County's extension, this new moratorium extension, is illegal on its face. So we're drafting it right now. We are going to be filing that lawsuit and seeking an injunction against this before it kicks in.
Well, good. I wish you good luck there. I mean, this has been a long, we're talking about over a 2-year fight now.
It'll be 3 years by the time this is all over.
Yeah, my goodness. Okay, so where we are so far is basically for some of the main reasons you typically would evict for, you can evict throughout most of this year. Now, when you said that unless it's a breach of the contract in some other shape or form, what would be some of those instances that you see would be a slam dunk, so to speak, in eviction court that a landlord, because if a landlord has a tenant who has tenants living there, they're not supposed to be living there, and they have a tenant that is a nuisance, but you're saying, hey, they've taken those away. Obviously now they're going to be drilling through their rental agreement saying, hey, is there something else that this tenant maybe is doing that they hadn't thought about? Any other, or what would be those issues that you would take a look at?
So, for example, let's say they were assigned parking spaces. I'm just using one that pops into my head, and the tenant, and they're prohibited from parking in fire lanes, for example. And the tenant consistently allows people to come over and park in their own space, and they go and park in the fire lane. That's one example. That would be a breach of the contract. And that is a situation that you would be permitted to go to court on that. There's plenty of them. Probably the most egregious one I can think of right now would be a provision in the lease that says no modifications to the property without the landlord's prior written consent. And the tenant goes ahead and installs a ring camera, a window unit air conditioning, starts building onto the property, at that point, yeah, you'd be able to go to court and file that eviction.
And what's the process for that now? Whatever the issue may be, whether they're parking, whether outside where they're designated, or they've made modifications to the unit. What's step one?
Step one is document it. Before you even say a word to the tenant, document the problems. Take pictures of it if you can, write it down, the date, time, witnesses, what happened, what was said by who. You want to document everything. Documentation is the key to winning lawsuits, or at least evictions. Once you've documented it thoroughly, and if it's, for example, if it's the parking issue, document it multiple times. Then I would tell you to serve a notice. And you might want to serve the notice with some form of an explanation that says, hey, pursuant to paragraph 9 of your lease, you're not permitted to, make modifications to the apartment. We've discovered that you installed a window unit, air conditioning unit on such and such date in the upstairs window. You're required to remove it within this number of days, et cetera. And I will tell you that you've got to figure out which jurisdiction controls your notices, because, for example, if you're under statewide just cause eviction, then you've got to give a notice that's a warning first. And then if they don't comply with the warning, then you do a 3-day quit. But if your property's not under the statewide, typically you would just do a 3-day cure covenant notice. You don't have to serve the second 3-day quit. So the first step is document it. The second step is to serve the appropriate notice. And the third step is, if they haven't cured it, you go ahead and file the eviction. And I would tell you, document the fact that they haven't cured it as well, because you'll need to prove that in court.
Now, let's say, because I know you serve other counties as well as we do, San Bernardino County, for example, where do things stand with evictions and rental increases right now, assuming we're not talking about a city that may have its own extra layer? In general, where are we with evictions and rental increases in San Bernardino County?
San Bernardino County is a little slice of heaven. So is Riverside. There's no moratoriums. There's no limitations on rent. I will tell your viewers, one of the things that has popped up, and we were going to talk about this in the new laws, is there's Penal Code 396, which is an anti-price gouging law, which states, there's a specific subdivision in there that states, in a state of emergency for a period of 180 days after that state of emergency is declared, a landlord cannot raise their rent more than 10%. So if you go to my website and you go under the resources tab, you'll see rent increase resources. Click on that. And then you will see the anti-price gouging link. Click on that and you can look it up by county, and it will tell you if that county has any states of emergency in effect and when they expire, et cetera. And the specific subdivision you want to look for, I believe, is subsection E. So in other words, it may have a state of emergency, but if it doesn't have an E after the penal code section, then it doesn't apply to landlords. So before landlords start increasing rents, even where they're allowed, like San Bernardino, Riverside, Orange County, go to the website and look it up and see if there's a state of emergency in effect that would prohibit them from doing increases of greater than 10%.
So no matter what duration of time the notice would be, 30-day or 60-day, you wouldn't be able to raise it more than 10% of the current.
In those jurisdictions, that's correct. Kris, you just said something that jogged my memory on something else. I'm glad you said it because your members are watching. The law changed a couple days ago. Laws change every day. The law changed a couple of years ago on the amount of notice is required to give a rent increase. So it's no longer 30 or 60. If your increase is greater than 10%, it's a 90-day notice.
And that's for the entire state of California?
That's the entire state, right.
And that's important because with the amount of inflation that we've seen this last year, when we get these new CPI readouts come May, I imagine there's going to be an opportunity to raise it more than 10% in some areas. If you have a 5% base plus CPI, can't imagine CPI is not going to be, say, 5-6% in some of these locations. So now it's 90 days and you may not even be able to increase it more than 10%, depending on if there's some special state of emergency in the city of which you own.
Correct. And also, if you're under statewide rent control, it doesn't matter. The maximum is 10%, no matter what CPI is. You can have a 6% CPI plus a 5% base, which would be 11%, but you're maxed out at 10 under statewide rent stabilization.
Oh, so that's interesting. So and for the viewers, the reason why Mike continues to say if you're under statewide is because there's certain types of properties like single family homes, for example, that are not under statewide rent control. And so there's certain types of real estate that are not under statewide. For those of you that are watching, you own multifamily, you're under statewide rent control unless your building was built within the last 15 years.
Correct.
And so basically for everyone watching, you cannot raise your rents more than 10%.
Correct, unless you're exempted by statewide for some reason.
Wow, this is this is all news. Now, so what about substantial improvement? I realize in LA County, that's not going to be allowed, but San Bernardino County, Riverside, Orange County, are you aware of any stipulations that say you cannot do substantial, ask tenants to vacate to do substantial improvements?
No, essentially, once you get outside of LA County, with one small exception, Santa Ana in Orange County has now got rent control and just cause eviction. But with putting that exception aside, once you get outside of LA County in Southern California, substantial improvement or substantial renovation is what it's called. There's no problem doing that. Before I get started, what I'm going to do, Kris, is share my screen. And I've got a slideshow that I'm going to use to walk people through it. And I want to be very direct up front. We're going to blow through the majority of it because there's so much that is taking place or has taken place and is in the process of taking place that I don't have time to do a deep dive on any of it in particular. We're also going to talk about some evolving trends and themes that we're seeing because you'll see those playing out in the bigger picture in the sense that you'll see where the laws are starting to go. And sometimes where a law gets passed and you're scratching your head going, why would they pass that? When you start to see these themes, you start to understand why. So having said that, let me share my screen real quick. So I'm going to put it on this screen first. Can you see my screen, Kris?
We can.
Okay. So the reason I'm putting this screen first is there's an email address right there. I want to give that to your members. If they have questions or they'd like a copy of these slides, I'm happy to send it to them. Just email me there and we'll get back to you as soon as we can. All right. So legislator overview. As everybody knows, Governor Newsom dodged a bullet. He stayed out of, the recall effort was unsuccessful. And so he remains in office. No surprise, he literally spent twice as much money. He spent $83 million while the combined efforts of everybody that was opposing him were $45 million. So he doubled their money and stayed in office. Democrats currently enjoy a supermajority, which means 75% or better in both houses. And that's a real problem. In fact, right now, their numbers are so great that in both houses, they need no Republican support whatsoever to get a bill passed. And they don't have to work with any of the Republicans to prevent a bill that they don't like from passing. So we're really kind of in a dire situation up in Sacramento as far as being a housing provider is concerned. But a supermajority makes it very easy for them to pass more taxes, which they're doing. Pass laws with urgency clauses, which means they can go into effect immediately, and to place measures on the ballot with absolutely no Republican support. 2022, everybody knows this is a primary election year, so it's very important. I really don't see any changes taking place even after the election. You'll see on there I have a redistricting, I have a headline redistricting. Last year, we did some redistricting numbers based on the latest census. And so that can also impact the vote, but I don't think it's going to. I think if anything, we're going to see more Democrats in the legislative makeup in Sacramento after the 2022 election. I will say that the new chairman of the Housing Committee is Buffy Wicks, and she is no friend at all to housing providers. And she has publicly stated now that it's her goal not only to get more Democrats in Sacramento, but to put more Democrats on the Housing Committee. So we're looking at a potentially ugly year for 2022. And now we'll move on to the legislative overview. 2,226 bills were introduced. A lot of them never go anywhere, and that's the case here, but approximately 835 of them made it to the governor's desk. 770 were signed, 66 were vetoed, and approximately 43 went to the governor that affect housing. 40 of those were signed, 3 of them were vetoed. I'm not going to go into every single bill that touched housing because a lot of them are not significant and they'd be a waste of time. We will talk about the ones that impact the landlords directly. All right, the bills that failed. First of all, let's talk about it real quick. Why do we care what bills failed? Why am I bringing it up? The importance of the bills that failed is, well, there's 2 reasons mainly. One is we work on a 2-year legislative session. So a bill that failed last year can come back this year and come back on it. And in fact, several of them have. The second and probably more important reason we care about the bills that failed is they give you a good sense of what the themes are that are evolving, what housing is trying to do, what the legislators and the housing committee are trying to do. So the ones that are most important are here on this screen. AB 1487, that was a homelessness prevention fund. And over the last decade, everybody's heard that buzz phrase, homelessness. That's changing, and I'll talk about that a little bit later. But that homelessness prevention fund did a lot of things, but mainly what it did was it was providing free eviction attorneys to anybody facing an eviction. Now, down here in LA County, that's old news. They've been dealing with the Schreiber Project for the last decade, but for counties outside of LA that have never had this problem that we face with these free attorneys, that law, had it passed, would have given every tenant a free attorney when they're facing an eviction. So luckily that did not pass. I anticipate that you'll see that coming back. We haven't seen it yet that I'm aware of for 2022, but it will be there. AB 899 and AB 1199, both by Gibson. These were kind of combined bills. Basically, what he's trying to do is get the corporate owners behind LLCs and corporations to have to not only register with the Secretary of State, but to pay an excise tax of 25% on their properties. And his stated reason for this is that you have these huge companies like Blackstone that beginning in 2008, when we had the foreclosure meltdown, they came in and started buying all these single family homes. And Gibson's stated reason for wanting this information is because he claims that it's preventing the locals in those areas from buying housing. And so he wants to know who these people are. Well, why does he want to know that? Well, one, he wants to tax them. And 2, he wants to be able to put the face of some big corporation on all of the anti-corporation housing laws that they want to pass. Hey, look, Blackstone's doing this. We need a law. Blackstone's doing this. It's all these greedy corporations that we're trying to stop. The reality is the laws don't stop the corporations. They impact the small mom and pops more than anything. But those 2 failed as well, thankfully. But we'll see they're coming back. AB 1188, Buffy Wicks attempted to do a county and a city rent registration, which failed. She's brought that back. She's brought the laws very similar to that multiple times now, and they keep failing, and she's going to keep continuing that. And SB 633, Limon, delivery of documents to guarantors. This one failed. I'll explain it in a second. I haven't seen it come back this year. I'm not too concerned about it. But essentially what it said is if you're a landlord and you're going to use a cosigner, you have to notify, in addition to the cosigning agreement, you have to notify them. You would have had to give them an additional document explaining to them that they're on the hook for the rent if the tenant doesn't pay. And it would have had to have been done in their primary language, something other than English. So that failed. And then SB 854, the Ellis Act prohibition, for anybody who's watching that doesn't already know what the Ellis Act is. The Ellis Act is a law that allows a landlord to go out of business. So essentially, if you ever get to a point where, let's say you had a single family home as one example, and you wanted to put your mom in it, you could take that home off the market. And even if it was covered by rent or just cause evictions, you could kick out the tenant and put your mom in it just by going out of business. And for the past 10 years, we've had at least 8 attempts to take Ellis Act off the books, and each one has failed. In fact, even in 2022, they attempted to bring it back, and it just failed yesterday. So I don't think that they'll give up on that, but it did fail for 2022. So right now, we're not facing an Ellis Act prohibition. But I will tell your listeners right now, Ellis Act is one of the major laws that is prohibited under most of these COVID moratoriums like LA County. All right, now let's talk about the bills that passed. Again, I'm not going to go into great detail, but these are just bills that pass that directly impact residential rentals. AB 838 code enforcement. Apparently what was happening is some agencies like Los Angeles County, for example, their housing enforcement, I'm making this up, they weren't doing this, but I'm just using them as an example. Los Angeles County Housing, where a tenant would complain about a habitability issue, sometimes the administrative agency would have a bunch of criteria that they would have to meet, the tenant would have to meet prior to the agency investigating the complaint. So maybe one of those criteria was, well, your rent has to be paid in full before we'll investigate any habitability claim. That has been removed. You can't do that anymore under this law. And under this law, it actually puts an affirmative obligation on the administrative agency to go investigate housing violations. AB 1177 Cal Account Bank Program. This one's really interesting. It'll give you an idea of where we're going, or at least an idea of where a direction we're starting to go. This one will be providing banking services for anybody who is alleged to be outside of your normal banking relationship. So it's claimed right now that approximately 5% of Californians do not have a traditional bank account. So, for example, one demographic that's often cited is illegal aliens have no traditional bank account. Technically, that's not true because the large banks, like Bank of America, for example, have specific programs targeted at those people to get them to have the bank accounts or to facilitate that bank account. But the tenants' rights advocates claim that that group of people are still intimidated and they're scared that they're going to be deported, so they don't go to the bank. So what California did was they created this Cal Account Bank Program that will pay landlords both the security deposit and, if necessary, rent. And if this gets implemented, or I should say when it gets implemented, the landlord will not have a choice. They will have to accept rent and the security deposit from this Cal Account Bank Program. So what we're seeing is the state of California stepping into a traditional banking institution role to facilitate this 5%. So that's really interesting. To the best of my knowledge, it's the first time I've ever heard of a state taking on a institutionalized banking role. AB 468, emotional support animals. I actually like this law, but I think it's a little bit half-baked. And what I mean by that is the law now says that before a physician can write a note to a landlord saying, hey, this person requires an emotional support animal, the physician has to have had an ongoing relationship with the tenant for 30 days or more, and they have to have had an in-person meeting with the tenant to make that determination. So what they got right was it's an attempt to shut down these internet websites where you pay $45 and some MD somewhere, in the Bahamas or something, writes you a note that says, hey, oh yeah, Kris German is disabled and needs an emotional support animal. What they got wrong with the law is it only targets licensed physicians. And the law does not require the note come from a licensed physician. What the law says, it can come from anybody who's in a position of authority to know that that person would benefit from the emotional support animal. So technically, my wife could write that note. So it got it halfway right. It hasn't plugged all of the holes yet, but it is a step in the right direction. We've got SB 60, which is a short-term rental law, another law that's really great intentions behind it, unless you're an Airbnb operator, in which case this is a terrible law. But essentially what this law allows is fines of $5,000 every time somebody is using their residential apartment as an Airbnb. And that goes back to your question before about what's a slam dunk case. It's interesting. We have a situation with the city of Santa Monica right now where an individual moved out of their apartment during COVID, and they claimed that they had to move out because of COVID. But what they did was they turned their apartment into an Airbnb. And under the Santa Monica moratorium and the LA County moratorium, you cannot evict people for unauthorized occupants. And so the city attorney for Santa Monica reached out to us and said, hey, what are you doing? You're trying to evict this guy. He's got unauthorized occupants. So we came back to them and said, hey, look, it's an unauthorized occupant is somebody who's living with you. It's a little bit different than you moving away entirely and using your apartment as Airbnb and profiting off of it simply because of the moratorium. So that's the kind of case where so far we've asked the city to provide their authority for telling us we don't have the right to move forward with the eviction. And instead of coming back with any authority, the city came back and said, hey, can we do a compromise here? So there is no authority. In other words, if your tenant is currently running their unit as an Airbnb, now's the time to pull the plug and try to evict them. We'll move on to AB 491, equal access to the property. That is a Section 8 law. So in other words, what the allegations were that landlords who were taking Section 8 because of the belief now that they have to take Section 8 were trying to relegate the Section 8 tenants to certain areas of the property. For example, they'd say, okay, all we have, because you're on Section 8, all we have is the second floor. And so that has now been made illegal. You cannot relegate anybody who's on any sort of housing subsidy to any sort of area of the property. And moreover, you cannot prevent them from being in any of the common areas of the property. So you can't say, because you're Section 8, you don't get access to the parking garage.
Right.
So again, that's something landlords really need to be aware of, because it does happen. And we'll talk about a little bit more later about the Section 8 aspect of, do you have to take Section 8 or you don't at a later part of this webinar. We've got AB 606, which is a labor law, finding and penalties. And basically what that says is if an employer, so we're talking people who have an on-site manager, for example, the employer is obviously the building owner. If an employer is found to have violations on one property or in one workplace, then they can be found to have, there's a presumption, a rebuttable presumption, but still a presumption that the same violations happen at all of their workplaces. So if you own 10 buildings and you've got 8 on-site managers and you get a violation at one building, you're now presumed to have those same violations at all 10 of your buildings. You can rebut it and overcome it, but the presumption is still there. So it makes it's just a hurdle that's costly to overcome, I'll say. We've got SB 727, which is a contractor's wage and penalties law. Basically, that says that the contractor is responsible for all the subcontractors' employees getting paid. It goes down the line now. So those are that's Section 1 of the bills that passed, and then we're into Section 2 now. And this will wrap it up for the bills that passed. SB 219, cancellation of property tax penalties and costs. This gives the tax collector the flexibility. They don't have to do it, but if a landlord has been negatively impacted by COVID, they can fill out this application, submit it to the tax collector. And if they can establish the impact of COVID, the tax collector has the ability to cancel the tax penalties for late payments. We've got SB 607, which I'll come back to. That's professions and vocations. And candidly, off the top of my head, I don't remember exactly what that law said. So I'll go on to SB 8, extension of the Housing Crisis Act of 2019. Same situation. Actually, these last 3 are important. We're going to see this trend growing. SB 9, duplexes and single family zoning, and SB 10, planning and zoning housing development. What you're starting to see is a upzoning law take effect. So realistically, what's happening in California is housing affordability is going down, and it's getting harder for everybody to afford houses. And so we've got a bunch of single family zoned areas that Sacramento has now said, hey, we have a housing shortage, housing affordability is getting more difficult, but we have a bunch of single family homes people are sitting on. We are now going to allow them to upzone, to turn their single family homes into duplexes, quads. I think it's Senate Bill 10 that allows up to 10 units on a lot right now. And so there's this moving theme or evolving theme of turning the single family neighborhoods into the multifamily properties. SB 8 was the Extension of Housing and Crisis Act of 2019. This law accelerates the approval process for housing projects such as ADUs. So what they're trying to do is they're streamlining the approval process on these ADUs so they can get more housing on the market. And then the SB 607 was we call it a fix to the balcony law. Previously, the balcony inspection law said the individual who inspects the balcony cannot be the same individual who does the work on it. And so a lot of the individual companies that were permitted to do the inspection were saying, we're not going to do it because we can't do the work. And so they fixed that law to say, now whoever does the inspection can also do the work. Now we'll talk about this later, but the inspections aren't due for another 4 or 5 years. So I don't see anybody, there's no benefit, there's no benefit right now to even running out and trying to get it done, because once you do it, the clock starts ticking and it has to be done every 6 years. So if you've got 4 more years, why do it today? But that's what that law is. All right, so we covered all the new laws that will be going into effect. Let's talk about the regulations. So this is what I was talking about before. This is this source of income and the definition of lawful income that has gone into effect now. And what it really means is previously, prior to the passage of this law, a landlord was not allowed to discriminate against an applicant based on their source of income. So as long as it was legal, you had to consider them. Now, Section 8 was specifically carved out of the definition as a source of income. So you didn't have to accept Section 8. If a tenant or an applicant applied to be a tenant, you could say, hey, we don't accept Section 8, and there would be no discrimination. But now Section 8 is included in the definition of lawful income. So if you say, and this ties into that next regulation below it, if you say we don't accept Section 8, you are unintentionally discriminating against somebody based on their source of income, which has now been made illegal. So be very, very careful. Even if you don't accept Section 8, be very careful not to put it in your ads. If you have on-site managers, you need to talk to them and tell them, do not discuss Section 8 with an applicant. If somebody calls you on the phone, candidly, I encourage people who think they're going to be dealing with this to call me and set up a consultation. There are ways around it, but I don't have the time right now, and I don't want to go into it on a video that's going to be put up on the internet, because as I've mentioned many times, the tenants' rights groups watch these videos too. And every time I put a strategy up there, that's the next law that comes out of Sacramento. Right. So if you're dealing with that, or you think you're going to be dealing with that, or you want to talk about how do you build that into your screening process, set up a consultation with me at my office and I'll walk you through it. The discrimination in advertising, it's the same thing. You can't express any sort of illegal preference of any kind in writing. So on your Craigslist or your Zillow ads, you can't say, don't accept Section 8, don't accept animals. You need to be really, really careful what you're wording. And it's one of those situations where less is better. And so if somebody's dealing with that and they want to know how to navigate it legally, set up a consultation with me. Call my office and ask to speak to Cynthia.
So you mentioned animals. So it is illegal to say we don't accept pets?
So you'll notice there's a distinction. I chose the word animals on purpose. Pets, you are allowed to say, I don't take pets. But service animals, including emotional support animals, are not pets. And so you wouldn't want to say we don't take animals. You could say we don't take pets. The problem with saying that is it opens the door. So I wouldn't say anything about pets or animals, because you don't want them to question you about it. You can have a no pets policy, that's fine, but keep that to yourself right now. Don't put it in writing, don't put it in your ads. And if you've got on-site managers, then you're concerned about that, you should set up the consultation, and we'll role play the most common telephone conversations and what you should be saying instead of making costly mistakes. And then the reasonable accommodation requests, this one, it's kind of a neutral law, but basically what it says is any reasonable accommodation request submitted by either an applicant or an existing tenant has to be kept confidential. And the way this comes up a lot is you have an on-site manager and the tenant walks over and submits their reasonable accommodation request. And maybe the tenant is open about it and tells another tenant on the property, yeah, I'm going to get a dog. You just watch. I'm going to get a comfort pet. I just submitted my application. Then the other tenant that has not yet requested the animal comes over and talks to the on-site manager and says, well, hey, I know Kris just turned in their application, and the on-site manager starts talking about the application, maybe mentions what Kris's disability is. It's that kind of stuff that is completely confidential now. The only exception to that confidentiality is you can release the information to somebody who is part of the interactive process or the interactive decision-making process. So for example, Kris, if somebody turned in a reasonable accommodation request to you and you weren't sure how to navigate it, you could pick up the phone and call me, and I'm part of your team that helps you navigate that decision-making process. So you'd be okay disclosing the information to me.
Got it.
But otherwise the information stays confidential. All of it does. All right. So now we're moving on to the recently introduced legislation. And again, this is just 2022, what's come up. In fact, a couple of these have died already, and I'll talk about that. AB 936, that streamlines the ADU additions and increased height limits process. So what was going on is currently we have a lot of landlords who already have an ADU or something like an ADU on their property, but they couldn't get it permitted because it's higher than the current height restrictions. This is streamlining that process to get that approved. Okay. They just want to get as much housing as they can online. AB 854, prohibitions on the Ellis Act removal, that just died yesterday. So that's gone for the year. AB 1241, Jones-Sawyer, this was the ban the box. This bill is in effect, this law is in effect in San Francisco. In fact, this is the law that says a landlord is not permitted to ask about any sort of conviction during the initial part of the screening process. So in other words, you weren't even allowed to have it on your application. Have you ever been convicted of a crime? But that died. The owner actually, the sponsor, Jones-Sawyer, actually pulled that bill off. It's dead. That bill's been around now for probably 5 years. Like I said, it's already in effect up in San Francisco. They will keep bringing it back. You will, even if it had passed, you will eventually be able to have some parameters and criteria. It simply says you can't ask about convictions in the initial phases of screening.
So for right now, my LA County, San Bernardino County, again, those areas you service that my clients own in, if an applicant has a prior criminal conviction, you can deny them simply based on that.
You can, but there are some caveats to it. So for example, you have to ask yourself several questions. How long ago was the conviction? What was the conviction for? So those are the two main questions. So if it was 20 years ago and it was conviction for drunk driving, if I were a landlord, I would not use that to disapprove of him or her.
But if it's theft, physical body harm to somebody else.
Yeah, absolutely.
Okay.
Yeah, so you can deny, but you want to be judicious in how you're approaching it. AB 889 is Gibson bringing back that corporate disclosure requirement. SB 140 is the framework. Now, this one's really interesting, the framework for the California Dream for All. So you remember we talked about that new law that passed that puts California into the traditional banking role, right? Mm-hmm. This Dream for All Act is, right now they're developing the framework so that the state of California will be providing the down payment for tenants to purchase properties, to be homeowners. It's not in place yet. They have to come back with a report. I think it's by July of 2020. Don't quote me on the year. I think it's July 2024. They come back with the framework for that. And if it's feasible, like I said, the state of California will be providing the down payment for the tenants to become homeowners. Now, that's really interesting. I'm going to circle back to that in a little bit when we get towards the evolving trends. We've got SB 649, which is the local low-income tenant preferences. This is a really interesting law because this is an attempt to prevent, it's an attempt to handcuff landlords when it comes to who they choose to be their tenants. So what this bill says is that if you have two equally qualified candidates, they don't even have to be equally qualified. If you have two applicants, one is very qualified, but they're not local. But another one is local, but they're really not qualified. They're low income tenant and they're not meeting your criteria. As a landlord, you would have to take the local tenant over the non-local qualified tenant if this bill passes. So again, it's really hamstringing the landlords in their abilities to pick the most qualified applicant. And it's forcing them, if it passes, it will force them to take a low-income tenant who's local over a high-income tenant who maybe is moving in from out of state or something.
So we should tell the banks, you got to base your application approvals on who lives closest to the branch as opposed to who could pay back the loan. Is that the
essentially? Yeah.
These people, the line of reasoning, it's a bleeding heart over rationale. Anyways, sorry.
No, it's all right. Well, it's pandering, really, is what it is. California is a state of renters, and certainly, of course, LA is a city of renters, but California is a state of renters. It's kind of a vicious circle. Every single law they pass has a negative impact on housing, but that gives them the battle cry that, hey, housing is very difficult here and unaffordable, so we need more laws. But every law they pass makes housing worse. So they don't seem to understand that, or they do understand it and they don't care.
Well, and again, people need to understand you can't just live everywhere. I want to own a home in Beverly Hills, but you know what? I can't afford it. So you buy what you can afford, right? But it's this mentality of, well, I want it now. Somebody owes it to me. There's people out there who have money, so they should pay for what I don't have. It's just...
You just nailed it, Kris. It's transfer of wealth. We're going to talk about that in the evolving trends, but essentially it is a socialist movement to transfer immense amounts of wealth from the people who have worked their rear ends off to establish this or to create this wealth to the people who are living in the apartment buildings. I'm not going to say they're not responsible, and I'm not going to say they haven't worked hard, but they have not done the steps necessary to amass this wealth. So the state of California is transferring it to them for free. All right, so SB 747, moving on, we've got grants to landlords denied rental assistance. This is a proposed law that any landlord that's been denied the rental assistance under Housing is Key or any of the local ones for COVID rental assistance funds, they will be able to apply for a $5,000 grant. Right now, I haven't seen all of the language of that bill, so I can't really talk about it in great detail. What I can say is I have some concerns, obviously. What if you're in the middle of an eviction and you fill out this grant and you accept that money? Does that kill your eviction? I don't know yet. So before anybody, if this passes, before anybody goes and runs out and starts filling out the paperwork, look into it, and they can call my office by then. I'll know more about it and figure it out. And then SB 848 is an increase in the renter tax credit. It's my understanding the tax credit hasn't been increased for renters since 1979, I believe it is. And I read somewhere that the increase is going up to, I think it was some enormously low rate, like $750 a year for a single person. That's being bumped up to $200,000 a year for a single person and $400,000 a year for a couple. So it's a huge increase in the renter tax credit. My concern with that, obviously, is California is now essentially giving renters a tax credit of up to $200,000. So the state of California doesn't walk away from money at any time. So if they're going to give the renters that tax credit, where are they going to pick up the taxes that they're losing? From the owners. And we've seen it many, many times. They're attempting the split roll tax. They're attempting to, get rid of Prop 13. They're attempting to reassess properties after Prop 19 passed, which we'll talk about in a second. So they're not just walking away from that money. Again, transfer of wealth to the tenants. Here, we're going to give you this huge tax credit. It'll lower your taxes, but don't worry about it. We're going to pick that up on the increased taxes on these owners over here. All right, moving on. Those are the bills that have been introduced in 2022 that we've just talked about. Now we're going to talk about the ballot initiatives. As we talked about in the beginning, 2022 is a primary election year for California, actually for the whole country. And here are some ballot initiatives. I don't have the time to go into them. Look it up and start understanding what is going to be on this ballot. And kind of as a joke, I'll just say, what difference does it make? Because everybody will remember that statewide rent control was on the ballot and the voters soundly defeated it. And then the state of California went and enacted it anyway. They just basically thumbed their nose at the voters. So I'm not sure the importance of these ballot initiatives, but they're here anyway. So the first one is local control over land use and zoning laws initiatives. That is giving the locals control over their zoning laws, which is, I know there's arguments for both sides, but essentially what we're going to see if that happens is a patchwork of zoning take place all over the state.
Right. There's no doubt we need housing, but do I want a 6-unit apartment building showing up in my neighborhood when I bought into a specific neighborhood? Because,
that's right.
Right.
Exactly right. We have the Tax Cut and Housing Affordability Act of 2022. I highly encourage people to look that up and understand the details, start educating themselves about these things. The Affordable Housing and Financial Accountability Act of 2022, same thing, please look it up. The Taxpayer Protection and Government Accountability Act, look it up. And my favorite, this is the one I will talk about, the Repeal the Death Tax Act. So Prop 19 passed last year, as everybody knows. And essentially what it said was, hey, when you die, your single family property is going to be reassessed and you won't be able to pass it on to your kids with that step up in basis the way you used to do. So the concern right now is that many of the kids who would have inherited those properties, they may not have the economic wherewithal to even pay for a stepped up yearly tax obligation. So this one is going to be on the ballot to pull 19 off, to get rid of Proposition 19 that passed and to do away with that. That one is sponsored by the Howard Jarvis Tax Association. All right, let's talk about, I'm not going to go into details in this, just to touch on them. The city of Alhambra is looking into its own just cause and rent stabilization ordinance. Beverly Hills is considering doing away with their moratorium, their eviction moratorium, but it won't matter because LA County's is kicking in and it's going to control the whole county. Right. Culver City had a seismic retrofit that went into effect. Glendale, they toyed with a tenants committee, but it actually failed. Los Angeles City and Los Angeles County, their moratoriums have been extended. Long Beach has a temporary restriction on substantial remodels. So you can't even do those right now in Long Beach. Manhattan Beach said as of March 1st, their eviction moratorium is rescinded. Again, it doesn't matter because they're part of LA County who's extending theirs. Oxnard and Ventura are toying with rent control and tenant protection acts. Pasadena, this is interesting. They had, I don't know if it passed, but they had on their city council agenda a bill to permanently ban all gas appliances in new construction and commercial. And it is not a secret that they are moving toward banning gas appliances, even in existing stock down the line. Mm-hmm. The problem, as everybody knows, is we don't have the grid. We don't have the infrastructure to start converting everything over to electric. So it'll be interesting to see how that plays out. Redondo Beach also considering, Redondo Beach is a really interesting one. I believe it passed, but now in order to remove a tree off your own private property, I'm not talking about an oak tree, I'm talking about any tree, you have to go to the city's planning and development department and ask them if you can get permission to remove the tree. And then West Hollywood, again, they're toying with the idea of revamping their tenant protections and moratoriums. So a lot going on all over the place in LA County.
Let me ask you, Mike, because as I hear this, and obviously things are always changing and developing. If a landlord is, say, using an older style rental agreement, or even let's say they're using the AOA rental agreement, given all the new regulations and the moratoriums and there's different notices for this and that, is it worthy of them too? And is it even something you do? If they come in and say, Mike, we need to meet. I own 2 10-unit buildings. I'd like to show you my rental agreement. Help me update this thing. Is there anything that I need to include? Or are there any additional notices? In other words, do you kind of do an overview consultation with them to help them clean up maybe what they haven't done in terms of documentation the last few years, to ensure, given all the new regulations in place, that they're within where they need to be? Is that something that you do? Is that advisable?
So let me paraphrase what you're asking. Will I meet with clients, review their leases, and give them an overview of what they need to do to be in a protected position, right?
Yeah, and even just if they say, hey, here's when I have a vacant unit, this is typically how I go about it. Here's a sample of my advertising.
Yeah.
Basically, you do an overview of their rental business, the legal aspect of it. Because as much as I know, I feel like I'm stepping in hot water, at least in 4 places, you know?
Yeah. So the leases we certainly will look at, and I do it all the time. I do it multiple times per week. I have consultations with people. They send me their documents. I review them before the meeting, and then we have an hour consultation on what needs to be done. And I'll tell you, Kris, it's surprising to me that these are still out there. But the one theme that I see virtually every time I look at leases is the attorney's fees provision in the lease is inadequate. So I'm going to take this opportunity to tell all of your listeners, review your attorney's fees provision in your leases. And if you have an uncapped attorney's fee provision, it'll say something like the prevailing parties entitled to reasonable costs and fees. That's an uncapped provision. If you have an uncapped provision, reach out to me immediately and I will draft you an addendum. It's $150. It's very cheap. We'll draft it and we'll serve an addendum changing that to protect you from evictions, from lawsuits, stuff like that. There's more to it than that. I've just summarized it. But that's the thing I would tell every landlord out there right now. At least twice a week, I run into this situation where I'm telling them, okay, the first thing you got to do, because oftentimes I run into situations where the landlord they should be doing an eviction right now. The laws are on their side to do this eviction, even in the moratoriums, but they've got this open-ended attorney's fees provision. And if they lose the eviction for whatever, a hyper-technical reason, the opposing side is going to come back to them after them for $25,000 to $30,000 in attorney's fees. So before we file on the eviction, what we do is we send out the change in terms of tenancies and change that attorney's fees provision to cap it at $500. And then, believe it or not, when these tenants' rights firms pick up these cases, they will bluff you still. They'll still demand a jury trial. They'll still hit you with discovery. But when it comes down where the rubber meets the road and it's time to actually have a jury trial, one of two things typically happens. They either waive the jury trial and have a bench trial, or they sub out of the case entirely and the tenant's on their own now, and that allows you to move forward with a bench trial rather than a jury trial. Why do they do that? Because if they know their fees are going to be capped at $500, even if they win, it's not worth their time and money to move forward with a jury trial. So I see that all the time. So the shorter answer to your question is yes, I do review this stuff all the time. Your listeners should call my office, set up a consultation. I'll look at their documents. We draft leases. I'm going to tell you they're not cheap, but they're incredibly thorough. Your typical trade organization lease right now with all the addendums is going to be anywhere between 3 pages to maybe 8 or 9 pages. My lease is going to be, we're closing in on about 30 to 35 pages, depending on what jurisdiction you're in. So it's built for 10 years down the road, anticipating all the changes that based on trends that I see, anticipating the upcoming trends and protecting the landlord for a decade.
Yeah. Well, and even I think I have a pretty good rental agreement. I have a really well-written addendum that was written by some attorney some time ago. And I think the idea is you just want to have your tenant, so to speak, wrapped in a straitjacket so that it's real clear. If they step outside the boundaries, it's real clear that they did so. And when you go to court, there's just no mistaking that given a sane judge, it should be in your favor. So anyways, Mike, I know that we have went through a mouthful today. I want to thank you again for your time. I know soon enough, you, I, and the other speakers we have will be together at our in-person educational event for the local landlords, where you'll be able to do a deeper dive and expand, more so on your opinions on how things are shaping up here in California and the trends that we see. But this definitely serves as a good opener and intro to the year. Hopefully there won't be much more change beyond what we've already seen. But thank you for helping us, the landlords, and getting us prepared for the rest of the year.
You're very welcome.
Excellent. Excellent. Well, I know our prior interviews have thousands and thousands of views. And the reason why is because we stand behind what you and your firm do, the quality of work, the attention to detail. So we highly recommend landlords seek your advice, and I hope they do so. And Mike, until we speak again, be well.
Looking forward to it, Kris. Thanks again.
All right, thank you.
With that, I hope you found today's show informative. I hope that you'll review your leases, take a look at your documentation. Do you need a consultation with an eviction attorney to see that you're in line, keep yourself out of hot water, and that you're advertising your vacant units correctly? As we know, the laws and regulations have everything to do with how our financial legacy works out in multifamily investments. Be sure to subscribe to our channel and share a comment with us. Are you finding the content helpful? What additional content could we provide that would be meaningful to your ownership? We're here to serve you, the landlords. Kris German, the apartment dealer, and as always, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.